But if he didn't, he sure as heck should have known those rules. Now, Justice Hammond has expertise in these issues. These issues need to be sorted out. We still have at large in New Zealand the issue of what sort of a business relationship between judges and counsel and judges who have relationships or friendships with counsel. That's obviously, that's not a step too far. But if you go further and you have a business relationship, is that too far? This is a very difficult issue with respect for the judiciary to deal with, in big part because New Zealand's a small country, and in part because we know now from things that we've seen in the media that there are business relationships between other justices, including the Chief Justice and senior counsel relating to horse partnerships. And the courts have got to ask themselves the question of whether a fair-minded third party who discovers that there has been a case in which the decision went against them when counsel for an opposing party has a relationship through a horse partnership with a Supreme Court judge. And I've got to say that if I was a litigant that lost, I think I would be questioning whether I had been dealt with fairly. I think as a reasonably fair-minded third party, I would be asking that question. And so I think that it's time for there to be some transparency around these rules. We have somewhat belatedly discovered that New Zealand does have some rules surrounding judicial conduct, which were promulgated in 2003, but for some reason kept secret in New Zealand until the last year. Indeed, the decision in the Court of Appeal in Muir and the Commission of Inland Revenue didn't make reference to the New Zealand guidelines. It referred instead to the Australian guidelines, which happen to be very similar, but it's strange that the New Zealand guidelines weren't referred to in the 2003 decision. So I call upon the justices at the most senior level in New Zealand to actually, I think, be reasonably transparent as to where they get to as to what is the level of appropriate or inappropriate relationship between judges and counsel when it involves business relationships. And I would suggest that given that we've got this expert, Justice Hammond, in the Court of Appeal, that they involve him. I think that they also have to include all of the justices of the Supreme Court, and perhaps they should also take some advice from the Law Commission. Mr. Speaker, there have been some mistakes made here also with respect to the Honourable Judith Collins. The Honourable Judith Collins. The judicial conduct complaint that came from that was considered by Sir David Gascoigne was imperfect. It didn't deal with some of the complaints that had been made by Saxmere, and it was too general in respect of the complaints that it made of Justice Wilson in respect of those that it did consider. And it was on that later ground. That the courts in the judicial review proceedings brought by Justice Wilson said that the findings of the judicial conduct complaints were deficient. That could have been fixed by Judith Collins, Honourable Judith Collins, because she was warned of that very issue by counsel for Saxmere and Radford after the Judicial Conduct Commission report came back. So, Mr. Speaker, it's a very sad day when we have this taint on our judiciary, and it is a taint. We have to acknowledge that it's a taint. I think in the end we got to the right decision where it was the judgment was recalled. There is a question as to why it's taking so long for the Court of Appeal to deliver their judgment in respect of the rehearing of the Saxmere and Radford case against the Wool Board, and I do hope that that is not being delayed on occasion of the retirement or the resignation of Justice Wilson. I do also have to say I think it's inappropriate to pay golden handshakes and large amount of costs on a solicitor-client basis. The costs of $475,000 seem patently excessive to me, and a $400,000 golden handshake in respect of someone who it appears has erred is inappropriate. This is a very, very serious matter. There are the issues as to whether the Attorney-General should have gone back to the Supreme Court and said, I've got this more information, Saxmere, Radford and the court need to know this officially rather than just through these back office routes. And there is also the issue as to whether Judith Collins should have listened to the warning that she had from Saxmere and Radford's counsel that the judicial complaint that was going to be forwarded to Muir was sufficiently particularised and didn't cover some of the issues that had been raised by Radford and Saxmere. Mr Speaker, the other issues that need to be looked at is what happened to the Woolboard money. There is still some murkiness around that, and also why it was that the Solicitor General or the Attorney General or some arm of government took this out personally on the person that was doing a public good and caused the dismissal of Sue Gray.
I regret to advise the member his time has expired.